is back. Swoosh. And that's the game. Nothing further, Your Honor.
So, Blake Lively walked into federal court with pages of arguments, a mountain of exhibits, and what I can only describe as the energy of someone who absolutely did not read the room. She asked Judge Lyman to punish Bryan Freedman, fine him, reprimand him on his professional record, make him pay her legal fees out of his own pocket, and she even tucked a little threat in the fine print about potentially having him removed from the case entirely. And Judge Lyman read every single word of it and wrote her back one paragraph, denied the motion, closed it, and went on with his Friday like she had asked him to fix a parking ticket instead of sanction the lead attorney on one of the highest-profile cases in the country. If you have been watching this channel for any length of time, you probably recognize the move immediately. The filing was only half the strategy. The headline was the other half. Blake Lively accuses Baldwin attorney of trying to poison the jury pool. That is the line that spreads. All of the major publications had versions of that up within a few hours. For a few days, it looked like momentum had shifted, and Blake's team let that story travel exactly the way it was supposed to. Several months later, Judge Lyman gave his answer and reminded everyone that filing something in federal court and actually winning it are two very different things, a lesson that Blake Lively keeps having to relearn at what I can only imagine is a significant hourly rate. Let me tell you what she was actually asking for, because the full ask is important context for understanding just how badly this landed. She wanted Freedman publicly reprimanded on his professional record as an attorney. She wanted him to personally pay her legal fees. She wanted costs, and she reserved the right to come back later and ask for something even bigger, which was having Freedman removed from the case entirely. Think about that for a second. Wayfarer walking into the most consequential stage of this entire litigation without the lawyer who has been running their defense since day one. That was the play. Silence him, punish him, embarrass him on the public record, or get him gone. That was the case she laid in front of the court. Judge Lyman reviewed it and reached a very different conclusion. Here is what he actually wrote, and I want to read it to you because it is short enough that we can just go through the whole thing right now. He wrote that even assuming, without deciding, that Freedman's statements were not protected, Blake had not shown that those statements, given when they were made, are substantially likely to prejudice any proceedings in this case. Accordingly, the motion is denied. That was the entire order. One paragraph and the motion was finished. Now, here is why the language Lyman used matters. He did not say Freedman did anything wrong. He did not say the statements were out of line, inappropriate, or even questionable. He did not rule on whether the professional conduct rules applied to what Freedman said at all. He went completely out of his way to avoid making that call. What he said instead is that even if we hand Blake every single benefit of the doubt on the legal question, even if we pretend for the sake of argument that Freedman said everything wrong that he possibly could have said, she still never showed the court how any of it was actually going to affect a jury. That was the entire foundation of the motion, and she could not prove it. A sanctions motion without that foundation is just a very expensive complaint dressed up in legal language. The timing issue is where this thing really collapsed, and it is not complicated once you understand it. Freedman made those public statements somewhere between 8 and 11 months before the trial date that existed at the time. Lyman essentially concluded that Blake never demonstrated a believable connection between comments made almost a year before trial and a jury being contaminated by them. She needed to show him a real path from point A to point B. What she showed him instead was a very long list of things Bryan Freedman said that she did not appreciate, and an argument that the court should therefore do something about it. Those are not the same thing, and Lyman was not interested in pretending they were. Now, here is the part that is going to be very satisfying for anyone who watched our expert report video, because this is where it gets genuinely awkward. For Blake's side, the expert who Blake paid $900 an hour calculated what this alleged smear campaign cost her. The expert spent several paragraphs inside that report building Bryan Freedman up as a credible and trusted voice in the entertainment industry, whose public statements carry real weight with real audiences. She established him as someone people listen to and someone whose words actually land with the public. That is what the expert report says about him, and then the exact same legal team that signed off on that expert report filed a completely separate motion in the same case, arguing that those same statements from that same credible and trusted voice were so harmful and so dangerous to the proceedings that the court needed to punish him for making them. You really cannot make this stuff up, and yet, here we are. There's also something in how Lyman wrote this order that Blake's team is not going to be able to work around later. He refused to decide whether Freedman's statements were protected under the professional conduct rules or not. Blake cannot point to this ruling later and tell anyone that the judge already concluded Freedman did something improper. He deliberately left that question open. He did not rule that Freedman was right. He ruled that Blake was not persuasive. That is the court telling you quietly and without much ceremony that you did not bring enough to make this worth deciding. What this motion really was, underneath all the legal formatting, was a press move that also happened to be filed in federal court. When you accuse the opposing attorney of trying to poison the jury pool, the entertainment press does not cover the procedural details. They cover the accusation. Blake Lively says Baldwin's lawyers sabotaged her case. That is the headline, and that is what spreads. By the time Judge Lyman responded months later, the news cycle had already moved on. The accusation traveled everywhere. The ruling arrived quietly. So that was the result of Blake's big sanctions push. Freedman is still on this case. He is still lead counsel for the Wayfarer parties, and he will be in that courtroom whenever this reaches trial, doing exactly what he has been doing since the beginning. Nothing in this order changes that. The motion that was supposed to punish him or remove him from the case is now just another closed entry on the docket. The bigger rulings are still coming. Those are the ones that will decide whether Blake's claims survive and whether any of this ever reaches a jury. And if this motion was any preview, the court is not particularly impressed with Blake's case so far. That's all.